Hi, and welcome to today's BCLT Privacy and Law Forum Life Sciences program. My name is Allison Schmidt. I'm the director of the Life Sciences Law and Policy Center. It's my pleasure to welcome you to today's program, AI, Privacy, and Life Sciences. We've got two real experts from Orrick here to take us through this thorny and complicated world. And without any further ado, I'm going to turn things over to them to get us started.
Great. Thank you so much, Allison, for having us today. I'm Shannon Yavorsky. I head up Orrick's cyber privacy and data innovation practice, and I co-head our AI practice. And I am joined by my partner, Thora Johnson. Thora, I'll hand over to you to introduce yourself.
Really happy to be here today. I'm Thora Johnson. I co-chair Orrick's Life Sciences and Health Tech practice, and I am a partner in our data group, and I focus exclusively on health data.
And we are thrilled to be here today talking to you about AI, privacy, and life sciences, a world that is changing very rapidly. And we're going to take you through some of the things that are happening in this space, what's happening with the law, and some practical points to think about as you work through these very topical issues. So let's start with the obvious. AI in healthcare is everywhere in the news. These headlines capture the excitement and the anxiety about what's possible with AI. From AI diagnosing diseases to streamlining hospital operations, the technology is reshaping how we think about care delivery along the full patient life cycle. AI can analyze imaging scans, pathology slides, and patient data to detect disease earlier and with really impressive accuracy. For example, spotting early stage cancers or rare conditions that might otherwise be missed. AI systems can help tailor treatments based on an individual's unique genetics, history, and real-time data, which moves us closer to truly personalized medicine. Hospitals are using AI to optimize scheduling, reduce patient wait times, and even predict staffing needs. And that means better use of resources and potentially lower costs. AI is speeding up the search for new treatments, analyzing vast data sets to identify promising drug candidates, repurposing existing medications for new uses. So much is happening in this space. And Tora's going to talk to you a little bit about how AI is used in healthcare and life sciences.
Thanks, Shannon. Not only do we see AI every day in the headlines, it's also really important to understand practically how it's being used in life sciences and in healthcare. For example, we see it in drug discovery. We see advanced AI systems such as AlphaFold. It was developed by Google's DeepMind, and it predicts the 3D structure of protein-based molecules solely on their amino acid sequences. And in fact, the headline on the previous slide was saying that AlphaFold is running out of data, so drug firms are building their own versions of AlphaFold. We see lots of work, promising work in genomics, and AI is being leveraged to analyze just massive amounts of genomic data, which we'll talk about a little bit. We see it in diagnostic imaging. So this is an old use case, and really I think one of the takeaways is AI isn't new to healthcare. We see radiologists who are leveraging AI to detect tumors earlier, and that continues to be a very important use case of AI in the healthcare space. We see AI being leveraged in clinical decision support. So it's summarizing patient histories and then flagging high-risk patients for additional care and treatment. We see virtual health assistants and chatbots being used to interface directly with patients to help them navigate their symptoms, and to help schedule care. And so the use of AI in that manner actually relieves some of the burden and some of the burnout that our healthcare providers are feeling. We see it in clinical trial design and recruitment. AI is being leveraged within EHRs to find and seek eligible participants for clinical trials. We see AI analyzing all of the continuous data that our wearable devices are generating every second of the day. We see it being used in billing, right? It's looking for mistakes in billing. And actually, you can see the provider side AI being used to generate bills. And then we can see it interacting on the health plan side by the insurance companies to look for risks or anomalies in the billing. So we see AI systems talking to AI. And then we see it in things like fertility prediction. It's tracking women's health and helping increase and generate success with IVF. So it's being used everywhere. But I really do want to come back to the point that the use of AI in healthcare is not new. It's getting a lot of attention these days, and it's being leveraged in life sciences in new ways, but it is a familiar concept.
So I'm going to talk a little bit about where all this data comes from. AI in healthcare is only as good as the data it's trained on, but getting access to that data, especially sensitive patient or clinical trial data, isn't always straightforward. Organizations need to ensure they have both the legal permissions and the technical infrastructure to access and retain the data. That includes data stored in EHRs, lab systems, and even biobanks. Each source comes with its own privacy, security, and technical integration challenges. We often see companies underestimate how long it takes to negotiate access to high quality clinical data, especially across institutions or borders. That's something Thora and I see all the time is companies trying to think about the different laws in different jurisdictions and how they can access that patient data across multiple different jurisdictions. A critical but sometimes overlooked issue is who owns the data and who has the right to use it. If the data comes from a hospital partner, research institution, or third-party provider, there may be restrictions on reuse or commercialization. And most of the time there are very robust restrictions or limitations on how that data can be used, if at all. And this is especially true for genomic data or data licensed from proprietary medical databases. Without clear ownership and usage rights, an AI product may be built on legally shaky ground. And that can be an existential risk to a product or service if a regulator turns or a commercial partner turns around and says, you actually don't have rights to the data that you built for the product that you built your data on. And we encourage organizations to lock this down really early before they train or launch any models, again, because it can be an existential issue. Even with access and IP sorted out, there are often contractual or regulatory limits on how data can be used. Examples include FDA or EMA rules, clinical trial protocols, privacy laws, research consents that define very specific terms for how data can be analyzed and shared. And sometimes data use agreements only allow for non-commercial research. And using that data in a commercial AI tool could breach the agreement. And this is where legal teams, compliance, and researchers need to work closely together because these restrictions can make or break the ability to bring an AI tool to the market. Something else that Thora and I are seeing here is de-identified data and all of the issues associated with whether medical or health data can be identified and reused for other purposes. And this comes with a whole host of issues under HIPAA, under the state privacy laws, under international privacy regimes like the GDPR, and something that needs to be carefully analyzed, especially in the context of AI, where there is a risk in a much larger data set that data that was previously considered de-identified could be tied to an identifier and be identified data. So a lot to think about there. So how do we achieve balance? On the one hand, There's this desire to make data widely available to enhance its value for ongoing scientific research and these wonderful goals around improved patient care. And then on the other side, there's protecting individual privacy. The more we can safely share and combine health data, the more insights we can unlock, improving diagnostics, accelerating research, and personalizing care. And aggregated diverse data sets help to reduce bias in AI models and ensure that tools work across different populations and not just a narrow few. But none of this is possible without trust. Patients need to know that data is protected, used ethically, and not being resold or misused or used for a purpose that they weren't informed about. And privacy here isn't just about compliance. It's about maintaining the integrity of the healthcare system and respecting individual privacy rights. We're seeing very sophisticated methods like federated learning, synthetic data, and differential privacy that help to gain insights without directly exposing sensitive personal information. But this is all needs to be very carefully evaluated. Again, going back to that de-identified data point, if the data is going to be reused for another purpose. So clear and transparent information being provided to individuals is really key. So patients understand how their data is being used, by whom, and that it's not going to be re-identified. So the goal is responsible. The goal for all of this is responsible innovation. We want to have improved diagnostics. We want to have accelerated research. We want to have personalized care. But it isn't sharing everything or locking everything down. It's being thoughtful and responsible about the ways in which to innovate with AI and designing systems that protect privacy while still advancing care. But again, going back to my earlier point, it takes collaboration across legal, technical, clinical, and ethical domains. So moving on to the next slide, I'm going to hand over to Thora here.
Thanks. Yes, so all really important concepts that Shannon just walked us through. And now we're going to spend a little bit of time diving into the details behind those concepts. And we're going to focus first on omics data, and then some time on health data, and then we're going to do a case study based around 23andMe. Next slide. So what is omics data? It refers to large-scale, high-throughput data sets that comprehensively profile various biological molecules within a cell, tissue, or organism. So genomics is probably the most familiar. It's the study of the entire DNA sequence, the genome of an organism. Then we have transcriptomics, the measurement of all RNA molecules, otherwise known as gene expression, in a sample. Then we have proteinomics, analysis of the complete set of proteins produced. Metabolomics, profiling of small molecule metabolites. And then we have I've got the history undergrad degree, not the scientific undergrad degree. And then we have microbiomics, the characterization of microbial communities, so the gut microbiome. And with the exception, and this is why it's such a thorny issue, with the exception of identical twins, each person's DNA sequence is unique and thus inherently, putting legal concepts to the side, inherently identifiable. But using omics data, complex as it is, can help us, when we leverage it with AI, help us with disease prediction, biomarker discovery, and personalized medicine. It is definitely where science is going. So again, we need to come back to Shannon's complicated description of advancing where we are in personalized medicine and privacy. And along those lines, if you go to the next slide, we have to consider the legal landscape that's in place to provide patients with the comfort to allow their data to be used to drive advancement. So as I indicated, a DNA sample can never be truly anonymized. The data around it, right? Names can be deleted and whatnot, but the underlying biological material, or if it's been processed and sequenced and now is being retained in digital format, it can never be truly anonymized. And there's studies to show that even anonymized data can be re-identified using genealogy websites. So just think about the cold case, right? You've got the DNA that's been kept for years and years and decades, and then it's run through a genealogy website, and you get a connection and you figure out who the killer actually was. So it's never truly anonymized. And we're going to talk a little bit more about it under the GDPR and then under California's consumer privacy law. But it's very hard to consider it to ever be truly de-identified in a legal sense under GDPR and the California consumer privacy law. And that's because there's always a reasonable possibility that the data could be re-identified or linked back to an individual. So, where does that lead us to? It leads us to a discussion around consent and secondary uses. So omics data is often collected for one research project, but then reused or licensed for AI training. And the problem is you got to look at the consent that the patient actually signed. Was it broad enough and specific enough to cover that reuse and that use for training AI? Did they know, for example, that their DNA would be used to develop and commercialize drugs? And then we have cross-border data transfers to take into consideration. So many life sciences companies are global or are training models using multiple omics data sets that have been sourced globally, which is what you want. You want a diverse data set when you are generating new drugs and therapeutics. And you need to consider the strict controls on cross-border transfer of bulk omics data. And we'll highlight from the US perspective what that looks like under a relatively new DOJ, Department of Justice rule. But before we do that, we go to the next slide. Let's talk about maybe a little bit of the shortfalls in US data privacy. We do have HIPAA, which does protect genetic information, but really it only protects it in medical and insurance contexts, right? HIPAA is a limited sliver of health data in the US. It protects protected health information, so patient identifiable health information that includes genetic information, but it needs to be in the hands of a healthcare provider or like a hospital or a health plan, a health insurer like the Aetnas and UHCs of the world. But there's a lot of data that's direct to consumer, particularly with genetic data. So we'll put a pin in that, come back to consumer genetic data. We also have the Genetic Information Non-Discrimination Act, which you would think that's great, that's going to protect all of the genetic data of US citizens, but it actually only prohibits health insurers and employers from using genetic data for coverage, benefits, and employment decisions. That's super important, but that leaves a lot that's not covered by GINA. So you really, when you look at both HIPAA and GINA, have to realize they do great for the data that they cover. They just don't cover all genetic data. And so what you have left is you do have this complex landscape of state privacy laws. So we have consumer privacy laws in 20-ish, depending on how you count, maybe a little more than 20 states that all treat health information as special category data that has enhanced consent and transparency requirements. But that's not every state. But we layer on top of that, there are maybe about a dozen states that have stricter laws that are particularly focused on genetic data that require separate and express consent for the transfer of genetic data and biospecimens, so enhanced protections, and some of those are criminal if you don't get consent where you're supposed to get consent, but it is very much a patchwork. And depending on the state that's involved, there may be a lack of information or lack of a law to protect consumers who are donating, providing their genetic information. So if you go to the next slide, I'm going to hand it over to you, Shannon, to talk about the DOJ rule that I foreshadowed.
Great. Excellent. So this is a topic near and dear to my heart, which is cross-border data transfer. And up until last year, the US had never had restrictions on transferring personal data outside of the US, which is just extraordinary because so many jurisdictions around the world have had restrictions and limitations and data localization requirements for the better part of 20 years. So this is really exceptional that we now have some new restrictions on cross-border data transfer. So as of April 8th of this year, the DOJ issued a bulk transfer rule that aims to prevent access to bulk US sensitive personal data and government-related data by certain foreign countries, which are called countries of concern and covered persons. So countries of concern includes China, Hong Kong and Macau, Cuba, Iran, North Korea, Russia, and Venezuela. Covered persons are foreign entities and individuals with significant ties to countries of concern. And it's not a control calculus, it's whether there's ownership. So we've had a lot of companies come to us and say, well, this is the ownership structure and this is who actually controls the entity. And we have to look at ownership rather than control, which is a really interesting distinction. And then there are bulk data transfer thresholds. So for certain kinds of health information, human genomic data and other human omic data, personal health data, there are thresholds. So if an organization is transferring in excess of this number of the data of this number of individuals, the rule is potentially triggered. And this has caused companies to really take a look at all of their different entity structure and partnerships and commercial agreements to try to identify whether they meet any of these thresholds, they're transferring data to any countries of concern. And then the next part of the calculus is whether it is a prohibited or restricted transaction. So there's lots that has to happen there. The DOJ rule describes different kinds of transactions. There's a prohibited transaction, which is data brokerage, which is incredibly broadly defined with countries of concern or covered persons. And it can be any access by countries of concern or covered persons to bulk human omics data or biospecimens from which such data could be derived. And so these are flat out prohibited. Then there's another level of restricted transactions, which are vendor, employment, or investment agreements with countries of concern or covered persons, which are permitted only if strict security and compliance measures are implemented. And these are the CISA security requirements. And I'm going to hand over to Thora to talk about some of the key exemptions which are relevant to life sciences.
Right, that's so helpful on the discussion of the prohibited and restricted transactions. There are exceptions, and I want to highlight a few of them that are particularly relevant for life sciences companies. So the first is for clinical and surveillance data. So data for FDA regulated clinical investigations or post-marketing surveillance is permitted to be transferred to a country of concern, but only if it is de-identified and pseudonymized per FDA rules. So it has to be tightly de-identified, and it's a very narrow exception. It has to be as reasonably necessary to monitor post-market safety and to ensure clinical research, right? Those were necessary exceptions. So they were baked into the rule, but it is only with de-identified data and only to the extent necessary for those services. Similarly, there is a regulatory approval exemption. So if data is needed for regulatory approval of a drug or device in a country of concern, that data can transfer, but it has to be de-identified, has to be synonymized, and it has to be required by the regulatory entity. So it is, again, a very narrow exception, but had in mind how life science companies actually work. So it's an important exception. The third one is for federally funded research, so data transactions under US government grants and contracts, but it is very narrow again. It doesn't have the same de-identified synonymized requirement, but collaboration with a US government is not enough, with the US government is not enough. It has to be a US government funded contract or research grant. So they exist, but they really need to be carefully analyzed in the particular circumstances to make sure they can be leveraged by the life sciences company. And then I think we're ready for the next slide.
All right. So I'm going to talk a little bit about exactly what constitutes health data under HIPAA and the GDPR, and then Thora is going to go into a little bit more detail. So under HIPAA, protected health information means individually identifiable health information that a covered entity creates or receives, is maintained or transmitted in any form, and is related to an individual's past, present, or future health. I think the key here is the covered entity. A lot of people get tripped up and think that HIPAA covers all kinds of health information, but it's actually pretty narrow. And the definition of covered entity describes a bucket of entities that are considered to be covered entities that are that create or receive health information. Under the GDPR, so under Europe's data protection legislation, data concerning health includes any personal data about a person's physical or mental health, healthcare services received, or information revealing health status, including medical data, which is doctor referrals, prescriptions, medical examination reports, lab test results, radiographs, and similar clinical records, and administrative and financial data, which is scheduling of medical appointments, invoices for healthcare services, medical certificates used for sick leave management. The interesting thing about health information under the GDPR is that it's a little bit of a complex legislative regime. You have the GDPR, but you also have some European member state specific health legislation. So you always have to look at the GDPR plus whatever the relevant member state has in place in terms of health related legislation. So I'm going to hand over to Thora to talk a little bit more about health data under HIPAA.
Right, so let's assume that we are properly working with PHI. So it's in the hands of a covered entity, a healthcare provider or insurer. And the question is, can it be leveraged and used to train AI? Or even just to be processed by AI in the delivery of healthcare? And the answer is, there's nothing particularly novel here. If you are using PHI and you're leveraging AI in the process, either as delivery of care or for training AI, if it is within the scope for treatment, payment, or healthcare operations, it's permissible under HIPAA. So if you're using, say, a chatbot to help deliver care, then you can process PHI, assuming that you have a business associate agreement if it's a third-party AI system. So a business associate flows down obligations to service providers under HIPAA to make sure they keep it private and confidential. There could be an argument that using and training PHI for AI is part of healthcare operations. But before leveraging that exception, you have to really carefully look at what you've said in your notice of privacy practices, what a reasonable patient would anticipate, and is there in and how strong the argument is that it is furthering healthcare operations. So it really needs to be a very thoughtful decision-making process if you're using PHI to train AI. And it doesn't come without risks, right? The easiest thing to do if you are training AI is to actually de-identify that data before you use it to train AI. And de-identification is a complicated concept under HIPAA. You either have to remove 19 identifiers, everything from what you think, name, address, email, SSN, to things that you might not think about, like all dates of service. And is that practical if you are using it to train AI? If you need to retain some of those identifiers, it may be possible to get an expert determination that what's left, even if it does include some of those 19 identifiers, doesn't result in more than a very slight risk of re-identification, and you get the expert to certify that that's the case. That is the safest way is to use de-identified data. And other things to think about is you really do have to be careful if you are using PHI in an AI system, because if there's any unauthorized use or disclosure of that PHI, it could trigger breach notification requirements, both under HIPAA and under state laws. I mentioned about having a business associate agreement in place with any third-party AI vendors. And because of the real scrutiny around uses and disclosures of PHI and whether you have the right ability to do so under treatment payment or healthcare operations, or otherwise need to get the patient consent or authorization, you need to have very strong policies in place with your employees over the use of AI tools to prevent inadvertent PHI uses and disclosures that are not actually permitted. And it's not, now I'm going to hand it back over to Shannon to talk about some of those risks under the GDPR.
And so under the GDPR, processing of sensitive health data is permitted only in very specific conditions if explicit consent from the data subject is obtained, and consent has to be specific, informed, freely given, and unambiguous, or that where the processing is allowed for preventative occupational medicine, medical diagnosis, health or social care, or management of health systems. And as I mentioned before, member states can introduce further conditions or limitations on processing genetic, biometric, or health data. So you're always having to read the GDPR alongside whatever member state law applies as well. So if you're collecting or using health data in Europe, you need to look at the GDPR and member state law as well. Key rights granted by the GDPR relevant to healthcare, similar to the US state privacy laws, there are a number of rights granted to individuals under the GDPR. The right to access data, the right to portability, and this is a really important one in the health data context, which is the ability to transfer health data from one healthcare provider to another in a format that is easily transferable. That can be technically complicated for healthcare providers, and the right to be forgotten. Individuals can request deletion and cessation of the processing of their health data. Okay, I'm going to hand back to Thora to talk about the FTC.
Right. So if it wasn't complicated enough, we did mention on the federal level HIPAA and GINA in the US. We also have the FTC, the Federal Trade Commission, which has been increasingly focused on enforcing privacy for health data outside the scope of HIPAA, so outside the hands of healthcare providers and health insurance companies. So think about the wearables that we all know and love and the health apps that are sold directly to consumers. And the FTC has targeted companies sharing health data with advertisers without consent. And they've been, at least in the prior administration, very focused on FTC's breach notification rule, which is related to individual health information outside of the HIPAA context. That's a little bit wait and see to see what the new administration will do, but believe that they will continue to have some focus on the privacy of health information. So we need to navigate HIPAA, we need to navigate GINA, we need to navigate the FTC, and then just as a reminder, we need to navigate the state consumer privacy laws that treat health data as sensitive and that require either an opt-out or an opt-in right for data processing. And then we have some states, which we didn't mention, Washington, Nevada, and Connecticut, that have additional consumer protections for health data, including a very strict consent requirement, even stricter, to its use and disclosure and private rights of action. Now, they all have various exceptions, including for PHI, which is regulated by HIPAA, and also for some research, but you really need to dig in and look at whether the research study that you're conducting falls within those exceptions. And then again, we have the state laws, some focus specifically on direct-to-consumer genetic testing, and we have state AI laws and automated decision-making in healthcare that attention needs to be given to. And if we go to the next slide, we're going back over to Europe to talk about the EU AI Act.
Great. So the EU AI Act adds an additional layer of complexity to European legislation. We talked about the GDPR, but now we have the EU AI Act, which regulates AI in Europe. And it really is a risk-based approach in relation to AI systems and divides the world into prohibited AI, which is AI practices that are deemed to be unacceptably risky, such as manipulative or deceptive AI. What's included in here are things like social scoring, high-risk AI, which imposes obligations and restrictions on AI systems which create a high risk to the health and safety or fundamental rights of natural persons. And it can be AI intended to be used for employment decisions. And this is very relevant in the healthcare context because there can be, a number of the systems that are being deployed in the healthcare context potentially create a risk to the health and safety of individuals. So a lot of our healthcare company clients are currently evaluating whether they fall into this bucket of high-risk AI. For a number of AI systems in Europe, there are transparency obligations that are imposed that certain AI systems that interact directly with individuals or expose individuals to AI-generated content have to be appropriately labeled. And then there's a bucket of general purpose AI. It imposes additional compliance obligations and restrictions on AI models that display significant generality and are capable of competently performing a wide range of distinct tasks, which can be integrated into a variety of downstream systems or applications. So this is a really important one and something that the final guidance just recently came out, and a number of our clients are thinking through, okay, are we high-risk AI or do we fall into this bucket of general purpose AI? And then what are our obligations that are derived from this classification? So moving on to high-risk AI requirements. This is when I talked about the different classifications. If you fall into this bucket of high-risk AI system, you have to establish, implement, document, maintain a risk management system. You have to establish data quality, management, and governance. So a lot of our clients are looking at what they're doing for data governance. Design and develop the AI system to achieve accuracy, robustness, and security. So looking at doing sandbox testing to ensure that the system produces accurate results. That's a long-standing problem with a number of AI systems, is accuracy and hallucinations. Technical documentation and automatic recording of logs. So really transparency and figuring out what technical documentation you need to develop. Conformity assessment procedures before sale and use. Register in an EU database, affix the CE marking, transparency information, human oversight. This is something that applies to a number of different applications of AI, is having a human in the loop, taking corrective actions if the AI system doesn't comply with the law, and immediately informing competent authorities of any, incident or malfunctioning of the AI system. And then upon request, demonstrating conformity of the AI system to the regulatory requirements. The reality is many of the AI use cases in life sciences are going to fall into this bucket of high risk AI, especially anything tied to diagnosing patients, guiding treatments, or any AI embedded in a medical device. So if your AI touches patient care, you're going to have to expect a higher compliance bar
And
and
on that
complying
note,
with all
uh,
these requirements.
sorry, Shannon.
No,
I
go
wanted
ahead.
to say that I wanted to make sure we hit that point from a U.S. perspective as well. So the FDA has oversight of um, both drugs and medical devices and has specific guidance around using AI and particularly around privacy and security and transparency. And we see that transparency point also under some of the state laws that are governing the use of AI, particularly in healthcare, and making sure that the patient knows that they're interacting with AI and how to bypass the AI system to get to a human. So I do think we've bounced back and forth a little bit between US and Europe's perspective on the use of AI in life sciences and in healthcare, but there is some unity in big concepts like privacy and cyber and transparency.
Yeah, a lot of similarities between the EU AI Act and emerging US state AI laws. And in Europe, I would just highlight that the fines are potentially very significant, up to 30 million euros or 6% of annual worldwide turnover. So higher than the fines, potential fines under the GDPR, which makes this pretty significant legislation. Okay. Moving on to the next slide. I kind of talked about this a little bit. The failure to comply leads to really incredible potential fines under the EU AI Act. We've included on the slide the range of potential fines that can be enforced by member state national competent authorities. And although the AI regulation doesn't provide for a specific right to compensation, a violation can potentially lead to civil claims of individuals under member state law. So just a lot of risk there, new risk landscape to really consider. Okay, I'm going to hand over to Thora to talk about 23andMe.
Right. We want to be quite practical here. So, 23andMe, direct to consumer genetic testing companies, 23andMe being an example of that, hold a vast amount of sensitive genetic and health data. And we talked a little bit about the legal gaps in the US as no federal privacy law. And HIPAA and GINA are not much help when it comes to a direct-to-consumer testing company like 23andMe and the others that exist. And so what we saw, which was very interesting in 23andMe, is it went bankrupt, and we have a bankruptcy court that came in and approved the transfer of the health information, including the genetic information, to a third party, in this case, a nonprofit. And that's of note and of interest because the 23andMe privacy policy did not always include a provision that allowed consumers to understand that their data would be transferred or could be transferred as part of a bankruptcy proceeding. And moreover, there are all those state laws that I mentioned, certain state laws, that require the consumer consent before their genetic data is disclosed. So there was a lot of discussion in the privacy ecosystem about how this sale could be approved. But this was in bankruptcy, and bankruptcy courts have certain processes and procedures and had the ability to approve the sale. And we've seen state AGs, particularly the AG in California, vigorously oppose the sale. But it's now been approved by the bankruptcy court, and the data has actually been transferred. And I should say that the nonprofit assuming the data has made very public representations about allowing individuals to delete their genetic data and their health data and need to consent to their data being used in research, and is appointing a privacy committee to help ensure and provide that balance that Shannon began our conversation with, of driving research and personalized medicine and making sure that consumers have the transparency that they need and a role in the approval and use of their data. So it's been very exciting to chat with you today, Shannon, about the use of AI in life sciences and in healthcare. And I do think it's important to say that it's just an evolution of what we saw early on with healthcare companies and the use of AI, particularly to identify in radiology abnormal results. And we just see it going through the roof, and a very exciting time. But there are this patchwork of both US and international laws that need to be kept in mind. And really, to the extent that folks in the audience have questions, we're happy to continue the dialogue. You can find both Shannon and me on Orrick's website and also through LinkedIn.
Thanks so much, everyone. Thanks, Thora.
Thanks, Shannon.
And I want to thank both of you so much for joining us. I learned a lot from your presentation, and I know that our audience will learn a lot as well. I really do encourage you to reach out to Shannon and Thora to continue the conversation once you've had an opportunity to view the video. Thank you so much to the audience for joining us, and stay tuned for our next program.